So, welcome everybody. By way of introduction, I'm Phil Reynolds. I'm a partner at FRP Advisory. I'm joined by one of my colleagues, Warren Brooking, and also have the pleasure to be joined by Tsang from Bateswell to give us a legal perspective. The aim of this session is to broadly cover an overview of the duties and potential risks facing charity trustees, particularly in the restructuring environment. The aim of today is to cover, effectively, broadly speaking, an element of about what actually are common directors' duties across. What a lot of people forget is that charities are mainly businesses. Charities will run schools, they run care homes, they run shops, they can run factories. So when people talk about charities, they forget actually they are at the heart of them, and most of them are underlying businesses as well. So when you deal with the matters in the charity sector, you have to bear in mind that as well as the Charities Act requirements, you also have the Companies Act requirements in the main that also impact on how those businesses operate and are managed. So the aim of today is to really kind of broadly cover through some of the main duties of charities trustees, a little bit about how the charities form and its legal structure then drives some of those issues. We then talk about how those trustees' duties change when we're entering into that kind of point of insolvency, that kind of twilight zone of operations where there are risks about future solvency and viability. We'll then cover some of the aspects around directors' disqualification and how that impacts on trustees. We will then cover a little bit around the role of the Charity Commission as the regulator of the sector for non-exempt charities. And we're also going to cover a few case studies. Glad to say that later on in this session, we're joined by David Grace, who was a former trustee of a charity that I was an administrator over, to give a little bit of a perspective from the trustees, particularly around the issues leading up to our appointment. And then we cover a few other bits. We also touch on a little bit on Kids Company A, because that was such a well publicised failure. And actually, the legal judgment helped codify a lot of the things that we're talking about. And at the end of that, if we're hopefully going to cover just a couple of slides on some of the practical advice. So if you're sitting in front of a charity trustees or their management team, we give you hopefully a little steer about the key things to discuss. Turning on to kind of directors' duties, there are effectively two main tests to establish proper conduct, and this applies to kind of directors as a whole. The first one is that objective test, which is effectively what is the general knowledge, skills, and experience that all fall into what should be reasonably expected to be done by a person carrying out these functions. So, very much looking at that objective lens at that director and what you would expect them to be able to do reasonably in that circumstance. You then have a kind of subjective test, which is the general knowledge, skill, and experience of that director actually has. Commonly with this is if you're dealing with a director who's an accountant by training, a solicitor by training, or another professional, you may hold them at a slightly higher standard of account and behaviour than you would maybe just a normal person off the street that hasn't had that benefit of that professional experience or expertise. The key thing, as with any director, is there are consequences if you breach those fiduciary duties, which could be anything from a disqualification for acting as a future director, potential personal liability issues, and for the repayment of damages, which is an issue which will particularly concern charity trustees who are doing this work out of the goodness of their heart and on an unpaid basis. And in the very extreme cases, the threat of criminal prosecution. Now, in terms of directors' duties, there was a recent case last year in Sequana, which helps clarify exactly how directors' duties kind of evolve. What we thought uses as a kind of a bookend slide to help inform some of the other discussions we'll have later. So effectively, this determined that there were effectively two key triggers that a board needed to look at. The first one was when there are strong concerns about the solvency of a business and where a potential administration or liquidation is, probable, but the key is not inevitable. What this happens here is we have the slow shift of movement of a director's and board's duties from acting on behalf of the shareholders, which is the primary duty, through to acting in the interests of the creditors, particularly where there could be a conflict between those two options. What effectively Sequana said is there's no one set point where this kind of duty flips, but it's a general spectrum where that shift in priorities changes as matters progress and develop. Now, the key then is the second trigger, which is when the directors knew or ought to have known that an insolvent liquidation or administration is inevitable. As soon as that second trigger is hit, the directors must treat the creditors' interest as paramount, and that's when that duty comes in. So I would recommend, if you get the chance to look at that case, there are some very good write-ups of it, but when you're advising a board on their duties, some of that guidance is gold, and just to help you clarify exactly what they should be doing at any one particular point in time. What I'd like to do is pass on to Jean, who's going to talk about particularly the charity trustees' duties in this respect.
So what is a charity then, looking at charity trustee duties? Well, in England and Wales, a charity is an organisation that's established for exclusively charitable purposes, and it falls under the jurisdiction of High Court charity law. Charities also have to provide a public benefit, either generally or to a sufficient section of the public. Now, normally, if your charity income exceeds £5,000 a year, you have to register with the Charity Commission. That's the charities regulator for England and Wales. Not all charities have to meet that income threshold before they need to register. If your organisation has a mixture of charitable and non-charitable purposes, then that won't meet the legal definition of a charity. I mean, in terms of duties, the charity law gives trustees a legal responsibility for the charity they're a trustee of, and to support this, the charities also have specific duties. The Charity Commission has lots of guidance on these things, and shows how trustees should really govern their charity and conduct themselves. The main duty of charity trustees, and we'll talk about the duties a little later, is to advance the purposes of their charity, and this should always be the trustees' main focus. And as I said earlier, a charity's trustees must carry out its charity's purposes for the public benefit. If you want to read further on this, there's Charity Commission Guidance 3 on the essential trustee, which is very helpful. And as Phil has already said, charity trustees are usually volunteers, so they're unpaid and usually doing this because of their generosity. And lastly, if you're a company director of a charitable company, then you are also a charity trustee. So turning now, the importance of legal form. So charities take many legal forms, as you can see on the diagram here. We've got companies limited by guarantee, foundations and trusts, charitable incorporated organisations, cathedrals, unincorporated associations. You can see also I've got here a community interest company. Well, technically that's not a charity, but I've included that here because it is an asset locked public benefit body, and so there's some specific insolvency legislation that will apply to it. So broadly speaking, the legal forms of charities fall into two main categories. That's unincorporated entities and incorporated entities. So technically, an unincorporated charity, so that's usually a charitable trust or a charitable and unincorporated association, cannot become insolvent because it doesn't have separate legal personality. So what does that mean? It means that the liabilities will sit with those who incurred them, and generally speaking, that's the trustees. So the trustees will be the people that enter into the contracts with suppliers. It will enter into the employment contracts with its staff, if it has any. It will be the one that takes on the property, if it has any. And so because an unincorporated association isn't a company insolvency legislation doesn't apply. And since the unincorporated association an unincorporated charity doesn't have legal personality, if the assets of that charity are insufficient to meet the charity's liabilities, then the trustees may have unlimited liability to meet the shortfall from their personal assets. And if they're unable to meet the liabilities personally, then bankruptcy legislation will apply. Here you can see that the trustees have joint and several liability. Now, what does that mean? It means that a creditor could go after any one all of the trustees for an unpaid debt. And moving on to incorporated charities, the ones that I tend to come across are charitable incorporated organisations and charitable companies limited by guarantee. As I said earlier, the company directors of a charitable company are the charity trustees as well. Company insolvency legislation will apply to charitable companies, and there's equivalent legislation for CIOs. And as we go through the slides today, it's important to remember that when we're talking about insolvency, it's a convenient term used in relation to all charities, regardless of their legal structure. So moving on now to the duties of charity trustees, looking at those in a little bit more detail. So we've said that the organisation has to demonstrate public benefit. So the charities trustees have a duty to further their objects, to comply with their governing document and the law. They've got, so ultimately, a duty to act in the charity's best interests. And so it's vital, for example, that the trustees manage conflicts of interest properly. Also here relevant is the duty to manage charities' resources responsibly. Now, it's vital that you implement appropriate financial controls and manage risks, such as having in place a reserves policy. And I know that Phil is going to be talking a little bit about that later. In terms of the duty to act with reasonable care and skill, it's really vital to take appropriate advice when needed, for example, buying or selling land or investing. The Charity Commission, the regulator, will often scrutinise a charity's minutes. So it's really important for the trustees to really have considered decisions, particularly big decisions, well, thought about what's relevant, assessed all the risks, and really properly documented that. The Charity Commission has helpful guidance called It's Your Decision that has helpful tools in there about how to make good decisions. And trustees who act in breach of their legal duties, they can be held responsible for consequences that flow from that breach or for any loss that the charity incurs as a result. And when the Charity Commission looks into cases of potential breach of trust or duty or other misconduct or mismanagement, it will take into account evidence that the trustees might have exposed the charity or its assets or its beneficiaries to harm or undue risk by not complying with legal requirements or following good practice. And over now to Phil to talk a little bit more about trustees' legal duties.
So in terms of trustees' legal duties, the key for trustees in these circumstances really is to make sure that they're, first of all, being covered by taking appropriate legal and professional advice. And secondly, just to make sure that they're continually contingency planning for the alternatives in this part of time. We'll hear from Trustee David Grace a little bit later in the session, where he will talk about, as the trustees, when do you take those decisions to particularly take insolvency practitioner advice and move from maybe deciding that the best interest is to try and keep the charity trading through to actually taking a decision that you need to close. Obviously, particularly in charities where people are involved for the very strong social commitment to the cause, it's very, very difficult. One of the bits I kind of semi-joke about is, and I always want to do an article about this, is how a lot of the time charities are very similar to football clubs, where the heart and the emotion of what you're dealing with gets in the way of proper business behaviour. You know, you will have football chairmen do things which they would never do in a million years in any of their other businesses. But for football, where they're committed, and as one chairman told me, you know, when he goes to work at his normal business, he doesn't have 500 people outside the office shouting and screaming at him, can generate decisions that you shouldn't be taking. And very similar with charities, we see that with the emotion and the desire, and for that cause to continue, means that people will avoid taking necessary decisions. And that's one of the areas where really, as insolvency practitioners and other advisors, we can give that cold, kind of dispassionate view to make sure that people are following their duties to protect themselves. We're passing on to Warren now, charity reserves.
Thank you, Phil. A reserves policy needs to be resilient. It also needs to be credible, transparent, and properly implemented. When I say credible, they need to develop a policy that justifies and explains keeping or not keeping reserves. They need to plan and identify for the maintenance of essential services. It needs to reflect the risks of unplanned closure from a financial perspective. How is that going to impact the business plan, forecast, spending commitments? And also from an operational perspective, how is it going to impact the beneficiaries, especially the most vulnerable, volunteers and staff? From a transparency perspective, it needs to be published, and it also needs to be tailored to the circumstances of the charity. I think it's also important that it explains to the stakeholders, the funders, the public, all of those other parties that are impacted, the commission, what reserves are being used and for what purpose and when are they going to be used. And for it to be properly implemented, it needs to be regularly reviewed and monitored and consider changes in the funding climate and other risks. My last point is that larger charities will also have more stringent reporting requirements. For example, in an annual report, they will have to assess their risks and show how they are managing them. I'll now move on to restricted funds. The key thing here is restricted funds have been given to a charity for a specific purpose, i.e., the party has specified how they would like the money to be spent. And it is then not possible for the charity to obtain those funds and then just use them for a completely different purpose. Examples of such restricted funding would be through emergency appeals, gifts, legacies, and again, they will all be for a specific project. The danger for trustees and charities are that those trustees can become liable if they end up using those funds not for the specific purpose. And again, that can happen because there aren't the proper controls in place, funds have been mixed, proper accounting policies in place. And I had an example recently where I don't think enough discipline had been carried out by the trustees. I think that they fell into the trap that perhaps we could just do one more fundraising event and that would address the problem. The danger with that is I think if your unrestricted funds go too low, you can end up in quite a messy situation from a pre-appointment perspective, because you will then have to go and contact those restricted funders and see if you can get their consent to cover the costs of a winding up. And post-appointment, you'd have to consider how will an office holder treat those funds and ultimately distribute them. I will now pass you back to Jean. Thanks.
So turning now to trustee duties in times of insolvency. So for as long as there is a reasonable prospect of the charity avoiding insolvent liquidation, the duties of its trustees are to ensure that the charity is carrying out its purpose for the public benefit. They act in the charity's best interests. They manage the charity's resources responsibly. They comply with the charity's governing document and the law, and they act with reasonable care and skill. If the trustees ought to conclude that the charity does not have a reasonable prospect of avoiding insolvent liquidation, then their primary duty will be to take all necessary steps to protect the interests of its creditors. And their main aim will therefore be to improve the creditor's situation, or at least stop it from worsening. Now, Phil and Warren have talked about the zone of insolvency, and that refers to the twilight period before the charity enters formal insolvency proceedings or is technically insolvent. And as a working guide, the trustee should regard that shift in their duties to the interests of creditors as occurring when the trustees know or ought to know that the charity is insolvent or bordering on insolvency, and that an insolvent liquidation or administration is probable. So just sort of practical tips. So ignorance of where the boundary of insolvency is won't be an excuse, though the trustees aren't expected to be able to predict the future. As I've said earlier, they should act reasonably and carefully record the actions that they take and the reasoning behind any decisions that they take, because they could be scrutinised. Other tips: trustees can't evade responsibility by leaving all the decision-making to only a select group of trustees. They all collectively have a legal obligation to be engaged with the process, and failure to do so could constitute a breach of their duties. For charitable companies and CIOs, if the charity goes into insolvent liquidation, then the liquidator is likely to consider such matters as trustee attendance at meetings and engagement in those meetings to assess whether there has been any breach of any trustee's duty to the charity. In terms of resigning, it can be very tempting for trustees to resign when their charity encounters serious financial difficulties. However, we would advise against this, as it can be viewed as a dereliction of their duties and is more likely to be frowned upon should the Insolvency Service or the Charity Commission conduct an investigation into the management of the charity during this difficult period. Of course, this doesn't extend to requiring trustees to make undue personal sacrifices in order to stay in office. For example, should their personal circumstances require them to retire, and that could be, family reasons could be a reason for retiring. We will touch a little bit upon this later, but trustees should also be aware that the Insolvency Service can apply to the court for an order to disqualify unfit directors of a charitable company for a period of up to 15 years. And the Charity Commission also has a charity trustee disqualification power. Turning now to Warren to talk about a case study involving an unincorporated charity.
Yes, this was the case of an unincorporated nursery that had worked in a deprived area of London for 30 years, so clearly done a lot of valuable work over a sustained period of time. Unfortunately, there were a number of factors that then led to the demise of the nursery. One was COVID. Secondly, I think there were issues with the premises. There was some mouse infestation, and also there was a material fall in the number of pupils. I think other factors to consider as well is how often the Board of Trustees tended to meet up. I think they used to meet up quarterly. The problem with that is in the summer, the issues didn't seem that serious, but by the time they then met up 3 months later, the position was far worse. Another danger here is the reliance on a particular individual. In this case, they relied a lot on one manager. And again, when they met up 3 months later, a lot of the actions they would have expected the manager to have done, the manager hadn't, and they were in a very difficult position. And then again, earlier, I talked about the importance of a reserves policy. In this case, during COVID, the charity, for whatever reason, hadn't signed up to the furlough scheme, and their reserves were materially depleted. The danger in all of this is obviously, as an unincorporated charity, the trustees now then could be personally liable for the debts of the charity so far as the charity is unable to meet them. And another mistake or something that the charities don't consider is actually, as well as existing liabilities, there can be contingent liabilities. And certainly on an insolvency, you have to be looking at the potential premises and also employee liabilities that can be triggered when the charity comes to an end. So again, it's very important, obviously, that the trustees try and get as much advice as early as they can, but ultimately they just have to be very, very careful about ever joining an unincorporated charity because of these risks. Okay, I will now pass you back to Phil.
Thank you, Warren. So what we thought we'd do is just do a little bit more of a deeper dive into kind of trustees' duties in this zone of insolvency. Now, this is very similar to the advice you'd give to a standard corporate director. And this advice, as Jean mentioned, includes to charitable companies and CIOs. So CIOs have their own separate kind of legislation which broadly mirrors the kind of Companies Act requirements. So the key really when you're looking at charities, you have to bear in mind that you've got effectively two main stakeholders. You've got the executive management team, and then you have the trustees. Obviously, the smaller the charity, the more those kind of boundaries get blurred, through to the larger charities where you will have two separate boards. The key then really is particularly that interaction between the management team and the Board of Trustees, and how that works, particularly when we're getting into a difficult position. Now, the other main issue really to bear in mind with charities is typically they run a lot thinner management and financial management teams than you would see in an equivalent commercial organisation. And as we all know, without the correct information, it's very hard to make the correct decisions. So as advisors, that's one of the key things we can really help with. Most of the time I work in the charity not-for-profit sector, my first point is to really help them build up a proper and a robust 13-week cash flow in order that you can actually try and see where you are and where the direction of travel is for that underlying business. So the key then is really making sure the trustees have everything they need to keep that operation under ongoing review. And again, that's where your cash flow is king for that position. The other bit, which obviously Warren mentioned on his case study, is trustees get them to realise that when things are turning south, that you need to actually be far more engaged than you might have been earlier. Saying, can we discuss this at the next trustees meeting in 2 months' time is not going to be good enough. So trying to get the commitment and the engagement of the trustees at this important time is key. And that's where really that interaction between the chair and the chief executive is vital to be able to get that engagement and get them focused on where they are. The last point there, which we've covered again, is the normal mantra. The trustees at that time should be getting that specialist legal and professional advice. See, a lot of charities, most of the ones I've dealt with, have been receiving kind of pro bono or low bono advice from law firms or accountants. And usually you would hope that they will flag you in as quickly as they can to the issue, so you can hopefully help. Turning to the next slide. Again, with everything, trustees have to be mindful about the risks of continuing to trade and or securing additional debt or giving guarantees and security, same as a normal corporate. And the key test there, as always, is that reasonable prospect. If they're reasonably comfortable that what they're doing should work, then the courts, if they ever look at this transaction, will look at that kindly. We will come on to how the courts actually deem the actions of charity trustees later on in here. But the key thing to bear in mind is the courts do recognise the special relationship that trustees have and the nature of their volunteer roles when considering these decisions. Broadly speaking, as with any corporate, if you can get to an informed view and the trustees can take an informed view, that is in the interests of the charity and its creditors to carry on trading out through its difficulties, then that will be deemed as an appropriate strategy to follow. The key is with all these things is no one expects directors to have a crystal ball and understand the future perfectly. But what they will be looking to, back to our subjective and objective test right at the start, is were these reasonable decisions in the circumstance and what was the bar behaviour expected? So if they follow that through, then trustees should be able to keep the business trading, keep the charity in operations, and avoid at the risk of personal liability and disqualification. But again, it is very much something you have to keep regularly updated and to review. And as we've talked about earlier on, things like restricted funds and that can get in the way of that because you've got some interested restrictions on how you can use the funds in that charity. I thought what we'd do next is just talk a little bit about the personal liability of directors. So this is one of the questions that will come up almost the first time when you speak to them. And again, this covers for charitable companies and CIOs. So the directors, and obviously bear in mind that trustees, if the charity is a company limited by guarantee, are also directors. Clearly, you have the risk of wrongful trading. You also have the sister of that if the events are so much more serious of fraudulent trading. Charities, they're corporate, so all the other toolkits we have as insolvency practitioners in terms of antecedent transactions still apply. That includes undervalued transactions, preferences, extortionate credit, and transactions defaulting creditors. So all of these issues are live when you're dealing with a charity. And obviously that can all lead to effectively a misfeasance claim for just general breach of fiduciary duties and for those directors to be personally liable. The other case on that is you can also have some potential personal liability for tax issues. Obviously for most charities, that's not so much of an issue. Bearing in mind those issues, they all count. So again, that point of documentation, minuting what you're doing, explaining the decisions you reached, and making sure that any particularly sensitive transaction is fully documented are key. As we said, obviously, if you're appointed as a liquidator or an administrator over a charitable company or CIO, you will be having that look back period. You will also have to report on the potential to a disqualification. Now, that, depending on the structure, it can be carried out by the Charities Commission or the normal insolvency service routine. So, obviously, the Charity Commission, as we will talk about later, are the regulator for the sector unless they're an exempt charity. One of the issues you always get when you're advising the board, particularly you've got trustees who are volunteers and have done this out of the goodness of their heart, is should they resign? Should they walk away from this and leave the issue? The way to deal with this is, first of all, to say that clearly any director is entitled to resign. But the key is that will not absolve them from any liability for their previous conduct or scrutiny by a previously appointed office holder. Now, my normal advice is to say to trustees in this situation is that your skills and experience are so much more important and needed at this point in time than probably anywhere else. And if you go now, you're really making it very difficult to save that charity. And surely it's better for you to be in the ring taking those decisions than being on the outside by resigning and not knowing what's going on. So very much using both a personal rationale for keeping involved and also for myself, a commercial view in that I don't want to lose a board of trustees because they're the ones trying to steer the ship at the moment. The other key point is normal kind of shadow director provisions still apply. Can be quite difficult when you're dealing with charities when there is probably that kind of muddying of the water between the trustees and the directors' views and who does what and who actually is carrying out these executive management positions of the company and how are they seen outside by individual suppliers, employees, the wider community. So again, all the shadow director and de facto director requirements still apply. And particularly when you're dealing with smaller charities, it can be quite difficult there where the boundaries get blurred. Last slide on personal liability of directors. Clearly, trustees as directors or trustees generally by way of the Charities Commission can be disqualified from acting as directors. The key things here, as everywhere, is particularly focused on any misfeasance by those directors. Now, in particular for charities, is the use or abuse of the funds in their control, particularly around restricted funds. If the trustees have allowed the use of restricted funds, which are trust funds, to be used for alternative purposes than what they were expressly provided to that charity to do, that can be a grounds for disqualification. And it's one of the biggest issues we have when we're dealing with charities is because usually the accounting is sometimes defective or deficient or inadequate, there can be mixing of funds and that control where normally on an ongoing basis, these accounts we've dealt with by the end of the year, but we are stuck halfway through a year where nothing's been reconciled, nothing's been accounted for, and it's a complete mess. And that can well be a grounds for disqualification. So part of when you're going in is to get that ship shape and get it back into a proper format. So if there is an issue, you can look at it and you can hopefully address it. What I'd like to now do is pass on back to Jean, who's going to talk about the role of the Charity Commission.
So the Charity Commission will recognise that once the trustees have concluded, or ought to have concluded, that there's no reasonable prospect of the charity avoiding insolvent liquidation, the trustees' duties will be primarily to the charity's creditors rather than to pursue its charitable purposes. So at that point, the Charity Commission will expect the trustees to make what's called a serious incident report to the Commission. And we're going to talk in the next few slides, I'll talk about that in a bit more detail. And once that report's made, the Charity Commission will expect the trustees to act in accordance with their duties and may seek assurance from them that they're doing that. And so it's quite helpful to explain to the Commission that trustees are acting on the advice of its professional advisors. And we'll talk about these in the next few slides also. But if the Charity Commission becomes concerned that the trustees are acting in breach of their duties or that there's been mismanagement or misconduct at the charity, then it has powers to intervene. So here you can see that it has the power, for example, to open what's called a statutory inquiry into the charity. It could appoint an interim manager, and it could also make orders disqualifying trustees from acting as trustees of that charity or any other charity for a certain period. So preparing the documents that Warren and Phil have discussed will be very helpful should the trustees be required to provide the Charity Commission with evidence that they have acted properly in managing the trustees' financial difficulties. So I mentioned at the point where you're entering into sort of significant financial difficulties, it's probably the time to really make a serious incident report to the Charity Commission. So what is a serious incident? Well, it's an adverse event for a charity, whether that's actual or alleged, which results or risks significant harm to the charity's beneficiaries, staff, volunteers, or others coming into contact with the charity, loss of the charity's money or assets, that's going to be very relevant to this presentation, damage to the charity's property, or harm to the charity's work or reputation. And so you can see there's guidance that the Charity Commission has on serious incident reporting, and they define significant as meaning significant in the context of your charity, taking into account the staff, the operations, the finances, and or its reputation. So the Charity Commission has a helpful examples table of what constitutes a serious incident and what doesn't, and it's there just as a guidance rather than being exhaustive. In relation to funding, I think in relation to sort of these financial distress and solvency situations, in the top right-hand corner, you can see when to report. So termination of major donor contract worth 20% of the charity's income, where a charity has no reserves, meaning that its staff will be laid off and its services stopped. So at that point, you would be making a serious incident report to the Commission. And in terms of practical tips, deciding whether or not to report an SIR, reasons pushing you in favour of reporting. So if the incident's already in the public domain or it's likely to be in the public soon, then I would highly recommend making that serious incident, because the Charity Commission hates it when a charity doesn't tell it about a serious incident and the Charity Commission first finds out about it from the press. Other examples may be where the charity needs support from the Commission to resolve the issue, such as specific consents or an authority, or else you might want to report if the issue is being reported to other agencies, so other regulators like the Information Commissioner's Office, the police, or the CQC, if you're regulated by the CQC. So reasons not to report yet include not having yet a clear picture of the situation. It might be a grey area and you haven't had an opportunity to brief the trustees yet. It's vital to maintain complete confidentiality for a short period. And on that point, I would say that the Charity Commission is pretty good. When you report things to the Commission, often what I do is say this is highly confidential, and if anyone approaches the Charity Commission, it would be great if the Charity Commission could tell us, the charity, and the Charity Commission will usually be helpful in that sense. If you decide not to report an SIR, then going back to the point about documenting decision making, make sure that's documented so that it can withstand any scrutiny should the Charity Commission ask to see your minutes. And I would say, if in doubt, err on the side of caution and make the report. It's done online and the trustee should be involved in that. So moving on to other Charity Commission interventions. So where there is suspected serious misconduct or mismanagement in the administration of the charity, or there's risk to the property held for charitable purposes, then the Charity Commission may decide to open a statutory inquiry to investigate those concerns, and it did so in the Kids Company case, which we'll be discussing a bit later. Where the Charity Commission opens a statutory inquiry, it also has the power to appoint an interim manager under Section 76 of the Charities Act, unless, of course, a liquidator has already been appointed. This appointee shouldn't be confused with an administrative receiver appointed in the interest of a secured creditor of a charity, whether that's under the Insolvency Act or otherwise. And with the interim manager, they can be appointed using the Commission's power where it satisfies the trustees haven't acted properly or where it perceives there to be risk to charity property. And in some cases, the appointment may be made in cooperation with the trustees. What does the interim manager do? Well, they can be given a range of instructions by the Commission, and that person normally fulfills the role of the trustees for the duration of their appointment. And this might include reviewing the overall viability of the charity. Separately, the Commission might also receive complaints about the trustees of a charity or about the way the insolvency or a situation was handled. If that's the case, then the Commission will consider such complaints in the same way as other complaints about a charity. Disqualification as a charity trustee is another power that the Charity Commission has. So this is separate to the company director's disqualification regime. So the Charity Commission has a discretionary power to make a disqualification order where certain statutory criteria that are set out in the Charities Act are met. And this essentially gives the Charity Commission very broad discretion, much broader discretion than the company's director's disqualification regime, to disqualify a trustee from serving as a trustee if the Charity Commission considers that action to be in the public interest. And if a disqualification order is given, it will state whether the person is disqualified in relation to all charities, specified charities, or a class of charities. The period of disqualification will depend on the seriousness of the case and can be for a maximum of 15 years. And when a person is disqualified from acting as a charity trustee, they're also disqualified from holding positions with senior management functions, whether paid or unpaid, within the charity or charities concerned, unless the Commission includes an exception in the disqualification order that that's not the case. So just turning now to a case study with David Grace, a former trustee of a vision impaired charity.
Thank you, Jean, for that. I thought I might just add just a couple of words about the role of an interim manager. So I'm on the panel for the Charity Commission to act as an interim manager. It's an interesting role. You're kind of quasi provisional liquidator or administrator. Your powers are determined by the order that the Charity Commission gives. So you will quite often heavily involve them to work out what you actually need. You're particularly entered into matters as an interim manager where there are clear concerns about fraud or other issues. So you're usually going into a live and hot issue. You're there to effectively carry out the nature of your order. I'm currently an interim manager of an evangelical church where there were concerns about the uses of the money that are being raised. And in that case, my role is to effectively protect the charity's assets, work out what's gone on with those charities' assets, and then see, in this case, whether there is the ability to rescue the charity by effectively seeing if we could implement a new trustee board. So in that case, as Jean said, your powers can be either inclusive or exclusive to the charity trustees. In this case, the charity's trustees have had their powers reduced and that they're solely responsible for the spiritual activities of the church, while everything financial and operational is dealt with by myself. So they can be quite interesting roles, but they are kind of quasi-interim. As an interim manager, they're broadly as either a provisional liquidation to protect the assets or effectively a quasi-administration to hopefully generate an outcome. As those cases normally involve fraud, I will quite often work with my forensic colleagues to help identify where funds have been used and whether there's opportunities to be able to get those funds back. So I'm pleased to say we're now joined by David Grace, who was a trustee of a charity that I dealt with. We thought it'd be useful to get kind of David's personal perspectives on the role of being a trustee and obviously what happens when things are not going according to plan. So welcome, David. Thank you for joining us. Maybe quite useful if you could maybe just give us a little bit of the brief history of the charity and how you got involved as a trustee and more importantly, why?
Yeah, no problem, Phil, and thanks for inviting me. I mean, a very interesting charity. It was a social enterprise that I got involved with called Clarity, which made and distributed soap and soap-related products. Actually, Britain's oldest social enterprise, formed in 1854. So it had been around for a long time, and I got involved in 2017, just as I was retiring as a partner from PricewaterhouseCoopers. And I was introduced to them actually by Ernst & Young, who were helping various of the then management team, providing sort of coaching help. To some extent, over its existence, it had changed quite considerably and it reinvented itself, pretty well, actually, obviously to have kept going for so long. Used to make mattresses and beds, for example, for the royal family, and then moved into soap and soap-related products in the 1930s, gradually expanded its product range to be a vast array of different soaps and soap-related products. When I got involved in 2017, it was doing all right, clearly finding life pretty tough, for a number of reasons, partly the product space it was in, But I mean, the important bit about the charity and what it was doing to add value was that most of the workforce was visually impaired or disabled or both. So probably of that 100 or so people we employed, 80 or 90 were, had a disability of some sort. So that made it very challenging obviously in a manufacturing context. So for example, we had to have cages for guide dogs to be put in during the working day and people to come in and take the dogs for a walk. So it was an inherently very complicated operation when I got involved. So semi-mechanized, which probably made it very difficult to make substantial profits and hard to see the true finances given the extent of government support and pro bono help. When I got involved in 2017, still very much an ongoing going concern business, making soap, gradually introducing new products and new ways of taking the products to market. The building blocks for a successful business were there. The problem, as Phil, you well know, was that given its long period of existence and the fact that it was probably 3 or 4 times the size of its current business levels if you went back a decade or so, was that it had a defined benefit pension scheme with a significant deficit. So that we had this massive liability, obviously at one level, nothing to do with the current employees or business sitting to one side. So that was the real challenge, I think, in common with many corporates and other charities.
Yeah, but it's obviously one of those problems where obviously the charities, it's part of the social compact with the staff that you might not pay them so much, but would offer them a better pension.
Yes, I mean, and the thing is, for the staff that we were employing, this was more than a job. So I don't know what the average age would have been, but probably plus 40. So these people that had been working in the charity, which, was obviously doing a fantastic social product, but it was their life. It was more than just a job for them. So that was a very significant factor once we started to get into more specific financial difficulties. And particularly, I think, in the charitable sector, obviously, a lot of the trustees had got involved because of their interest in the social side of it, quite rightly. So that caused a lot of tensions, I think, amongst the board, both before we got into difficulties and throughout the then process we followed.
Probably leading on from that, I'd be quite interested about that decision point when, as trustees, you decided to take professional advice.
We gave it a good go to try and turn the business around, for want of a better way of putting it, and introducing new products. And I'd say the trading side of the business was steadily improving. I mean, we had massive corporates as clients, including my old firm and many investment banks, and we were into most of the major supermarkets. So the building blocks in that sense of new products and slimming down the product line, targeting green soap and green soap related products had gone very well. The problem always remained this pension scheme deficit in the background. Amongst the board members, there were not very many accountants like me. So we were seen as the voice of doom and gloom sitting at one side of the table. And obviously the others were there very much driven by purpose rather than, it's very different, as you know, from a corporate board, which it's got elements of corporate greed, etc. Here, people are motivated to be involved by their sense of purpose and their support for the underlying objectives of the charity. So the accountants on the board were saying, we've got this deficit. The deficit, in common with many others, was growing. The funding requirement was going to grow. I think it got to the stage where the accountants and some others kept saying that we've got to take professional advice on this because the funding requirement going forward is not, even if the business, trebles in profitability, it's not going to be able to meet the funding requirement. What then became apparent was they were not necessarily going to believe the disaster scenario that we were trying to portray without someone independent putting the messages across to them in quite a sensitive way. Another challenge, by the way, was, which I'm not a fan of, is no one from management was on the board, which is common with charities and social enterprises. So you've got this non-executive type trustee arrangement, and the management, there's a disconnect, I think, once you get into financial difficulties. So that in the background wasn't helping. So it was very important for us to get your advice and independent legal advice, I think, both for the management team and the trustees. So I think that was the critical reason why we got people involved. I think to the the more professional people professional in the sense of qualified people on the board, they could see the problem. The rest of the board, who were bringing major benefits in other areas, couldn't see the problem and thought everything would be all right. Partly because it had been going for so many years, everything had been all right at different points in time for various different reasons.
Obviously, as you mentioned, obviously one of the biggest issues was the pension scheme liability. It was at a level of the level of deficit which just couldn't be supported by the ongoing activities. I mean, looking back, obviously before the decision was made to kind of place the company into administration, is there anything you think as trustees you could have done any differently, or do you think the die had been set by those original decisions to grant the pensions?
Well, that's a very good question, and one which I've thought about a lot, both before, during and after. Yeah, I mean, I think if we'd been aware of the inevitability probably of what was going to happen, given the way pension regulators have sort of put the pressure on employers to increase funding contributions, I think the sooner we'd have got, and you and your firm obviously got in touch with the regulators at the right time. Maybe if we'd got in touch with them earlier, we might have been able to come to some other sort of arrangement. I mean, I think it's probably unlikely. It might also be worth saying whether it was a social enterprise that had in some ways had its day, I'm not sure. A manufacturing operation largely staffed by vulnerable people in North London. You know, I think it worked during its existence better than it could ever work in this day and age, with much more highly mechanised soap producers. You know, it's very dependent on government support. So I think it was inherently doomed. It was the wrong answer, of course, because, all these vulnerable people, we were providing their livelihoods and giving them a social life as well as the money. So, it's very, very difficult. And I think, obviously, when we did come to do a pre-pack administration, everybody really wanted to prioritise the interests of our workforce and to safeguard the charity and charitable purpose. Whereas, obviously, the pressure then it switches. So you have to prioritise the interest of creditors. So the non-accountant legal people on the board that was very difficult. So that was another area where it was really critical to get your advice and legal advice to explain what we could do and what we couldn't do.
Yeah, for the audience, I mean, that was one of the biggest issues we had, obviously, as an administrator, our duty to kind of try and maximise returns to the creditors, kind of balance that against the social. And in this case, we had effectively a charity and a private party looking to acquire the business. And obviously, I'm slightly hamstrung in terms of being an administrator in terms of the offer that I accepted.
Actually, and going back to your last question, in an ideal world, I think, a year before I got in touch with you, I would have got in touch with you if I was playing it back again. I'd have got in touch with you a year earlier, got advice, and then got you much more involved from trying to restructure it and find a high net worth individual that will put money in it, rather than have left it.
Yeah, it's a common refrain in our industry that if you tell me you run out of money at the end of the week, there's limited things I can do. But if you let me know 6 months earlier, we have opportunities. And I think from my side, looking back, there were a couple other charities we could have approached. We just didn't have the time to really see if there was a rescue.
And it would have been complicated because the pension regulators would have had to have been a key part of that. But they might have been. But obviously, they take a fairly hard line on these large deficits.
But that's great. So, David, thank you very much for sharing your perspectives there. I thought it was important to try and give our audience a little bit of the human view on this. And at the end of the day, this charity was employing a lot of vulnerable people who, unfortunately, the operations fully closed, and obviously they lost a big part of their self-worth, because work at the end of the day does give people some validation.
We had a very good trustee board. It was very diverse, actually. So the trustees that were, very, very focused on the social purpose were, although it caused tensions, it was a very effective way of pulling us back to the underlying good that the charity was doing. And it made us try even harder, I think. Probably professionals and trustees, even harder to try and find a workable solution. So it was, very positive in that sense.
Hopefully everyone found that discussion with David Grace helpful. and a little bit informative, and really just to drive home that kind of human aspect when you're dealing with a charity. We'd now like to just run through Kids Company, which a couple of years ago now, but such a high profile matter, and the decisions in that are still relevant today.
So Kids Company. So I thought it'd be helpful to run through the background to this. The Kids Company was a well-known charity which provided practical, emotional and educational support to deprived inner city children and young people in London and Bristol. Why did it close? While its finances had become severely stretched by late 2014, the charity sought additional government and other funding to ensure its survival. Negotiations at the time with the government were positive, but they were slow and they didn't proceed entirely as hoped. There were other issues as well. Anyway, fast forward, the charity went insolvent in 2015. And in that case, the official receiver being an officer of the insolvency service, carried out an investigation into the management and affairs of the charity and the causes of its failure. And the investigation culminated in director disqualification claims being issued against the Kids Company's former trustees and its chief executive, Camilla Batmanjala. And the High Court heard the case at the end of 2020. So in this case, the official receiver sought disqualification orders on the grounds that the chief exec, whom he claimed was a de facto director, and the actual directors, that's the charity trustees, were unfit to be concerned in the management of a company. And the main allegation was that the defendants caused or allowed Kids Company to operate what they said was an unsustainable business model, and that this was supported by a wide-ranging web of mini allegations regarding Kids Company's operations, from low levels of reserves to policy compliance. In this case, there weren't any allegations of dishonesty or self-serving conduct or criticism of spending on any individual. Instead, the case concerned the alleged incompetence of the board and the chief executive in their management of the charity and its finances in particular. There was a 10-week trial, and the High Court dismissed all of the official receiver's allegations. The court found that the chief executive was not a de facto director and that the trustees had made honest judgments within the range of reasonable decisions in difficult circumstances in what they thought were the charity's best interests. The judge also said that they were highly impressive and dedicated individuals who selflessly gave up enormous amounts of their time to what clearly was a highly challenging trusteeship. The court also concluded that it would not have found the charity executive unfit had it found that she was also a de facto director. So the upshot of this is that the law is unchanged in relation to the duties and liabilities of charity trustees. So is the outcome of this case good or bad news for charity trustees? Well, certainly the existence of this case, to begin with, has shaken the confidence of a sector already struggling with regulatory burden. And so this case regularly comes up as a cautionary case study in the context of charity trustee training and board decisions. Although it's difficult to quantify its impact on trustee recruitment, a case of this nature carries a high risk of deterring able and experienced individuals from becoming or remaining charity trustees, as the court recognised. But the defendant's resounding victory is good news for the sector and charity trustees as a whole. It sends a clear message that bringing proceedings against trustees, other than in the clearest of cases, is not in the public interest, and that trustees will receive the protection of the court when making honest and reasonable judgments in the interests of their charity. And so we hope that the outcome of this will restore confidence in the sector and on charity boards. One question that I'm often asked is, was the court lenient on the defendants because they were trustees of a charity? So there's a long-standing principle that the courts will look benevolently on volunteer charity trustees so as to recognise the efforts of those who give unpaid public service and not to deter people from becoming trustees. So this principle was recognised in this case, but it didn't form the basis of the court's decision. The court certainly didn't hold the defendants to a lower standard because they were trustees of a charity. Rather, the court recognised that in accordance with established case law, that the court must take into account the context in which a director is operating. An unpaid, part-time, non-exec director who primarily discharges their duties and functions at intermittent trustee meetings, that might be 4 times a year, won't have the same level of control or knowledge or oversight as a paid executive director who's working at a company on a day-to-day basis. And so this was relevant to the court's determination of what the director knew and should have known and their actions during the period in question for Kids Company. It's also relevant to say that there was a Charity Commission statutory inquiry that followed the court case, and the Charity Commission concluded that the legal test hadn't been met for it to take regulatory action against the former trustees or the CEO of Kids Company. And that was in large part due to the High Court judgment not disqualifying them as directors. Are there learnings from this case? Yes, and I will turn now to Phil to go through those with you.
Yes, so there are a couple of issues. I mean, I think the key thing with Kids Company, as Jean said, was, the courts were clearly looking at the potentially chilling effect a negative judgment in this case could give, reflecting how vital that kind of third sector role is to our economy and to deliver the societal aims that we all want to achieve. I do have personally a few issues with that judgment. We were not dealing with a body of trustees in that case that were anyway inexperienced. They'd held substantial senior positions managing multi-million-pound projects, managing hundreds of staff, but it was a kind of salutary lesson about the perils when you're working with such a charismatic individual, hard to stand up to. In that case, I think the succession of FDs that the charity had gone through is always a big warning sign. But the other key point for me really was this, effectively the challenge around insufficient reserves, which I thought was probably one of the strongest points they had, because Kids Company had consistently effectively spent every single penny that had been generated. Now, rightly, they were a charity that had the eye of government and, was certainly a popular cause for funding. So, in one respect, you could say, well, you're best spending every penny you have because that's the way to maximize your value. But the challenge there really was that as soon as there was any slight difficulty, unexpected costs with the charity, there was no reserves to be able to meet those. It's always quite an interesting position to get to. I know with reserves, if you look at them in a moment, say the Premier League's kind of in-house charity has no reserves because their assumption is the Premier League will always fund them through, against some heavy research-based medical charities that will hold reserves which are equivalent to 10, 20 years of their operating expenses, because that's the length of the projects that they're looking to fund through in order to develop a new medicine or treatment. So there is no one-size-fits-all scenario here, but project-based charities should at least make sure they're keeping behind everything they need to do to be able to complete their work and cover redundancy costs for those staff. Big issue, and I think that was one of the bits that probably got lost a little bit in Kids Company, where being if they'd actually reserved a bit more money, that could have been a soft landing, because the key there at the end was 700 kids suddenly lost all support overnight, and that's something really as a society we don't want to happen again. A couple other little bits that came out of that judgment. One was effectively that clear guidance that if you're an active trustee, you're not going to be seen in any worse light than a passive trustee. And similarly, if you resign as a trustee, that's not going to treat you any differently than a trustee who stays to try and fight through and help with the issues. The key then really is that dishonesty, no personal gain, and no lack of probity. If you've got those, clearly as trustees, it would not be in the interest of pursuing you for disqualification. But going back to the points we said before, key is having that information to hand so you can make sure you can justify and document your decisions. And that was one good thing with Kids Company, because it was clear that there was lots and lots of engagement, lots and lots of discussion, and the Insolvency Service probably didn't really give that as much credit as they should have. So where does that lead us to? So in terms of practical advice you can give to nervous trustees, and when you get that call, they will be nervous. Typically, they'd have been to a lawyer who maybe isn't a charity specialist or a restructuring specialist and been frightened to death with fears of wrongful trading. So what can you do? So The key is obviously making sure that those trustees are aware of both the cash flow and balance sheet tests for insolvency, and that this boundary isn't inflexible. There is a whole shade of grey in between. They do not need to immediately pull the plug and turn things off, until you've carried out a proper assessment. Key things, as with any other company, can you help defer payments to key creditors? When you're dealing with a charity, in most of the cases, creditors and suppliers will be supportive. So if you need indulgence, you should ask, because you might be surprised that you will get that indulgence needed. If you're carrying out redundancies, again, you need to make sure they're done properly. But again, staff will potentially show more flexibility as it's a charity if you need to do things quicker than otherwise they're able to. Termination rights and contracts are all key things to look at. HMRC, obviously you've still got PAYE, NI liabilities. HMRC will look at matters kindly, and you may have more chance of a time to pay with a charity than with any other organisation at the present. The other kind of point really is about those kind of restricted or designated funds. Can you talk to those funders? Can you get them to undesignate those funds, make them unrestricted in nature so they can be used to cover overheads? What I've seen with a lot of charities is they have a lot of restricted funds but don't have the unrestricted funds. And if they haven't got their funding agreements right, they haven't the ability to use an element of those restricted funds to cover the general overheads of the business. And that's where they get into problems. So, who's paying for the normal admin staff, who's paying for the other overheads of the charity while you're carrying out the work for these restricted funders? Making sure that you've got a 10-15% contribution from those restricted funds that has the ability to be used for those general overheads. Those are kind of key things we need to look at. Going on to the you'll be glad to hear the final slide of where we are. Trustees are jointly and severally liable. So, they need to make decisions jointly as a board. And as we said earlier on, ideally don't resign at this point in time. We need to keep people in the tent to make those decisions if we are going to save that charity. Key test in all of this is reasonableness. The key is, did those trustees act reasonable in the circumstances? So did they seek advice? Did they keep contemporaneous written records of all decisions and, vitally, the rationale behind those decisions? As we've gone back to, no one expects those trustees to have a crystal ball, but based on the circumstances, was it reasonable and objective to reach those decisions? Hold those regular board meetings. If you have to get the trustees to engage more, you need to get them to engage more. Undertake that regular risk analysis, that what if scenario planning, that contingency planning. All of that is key for what you need to do. Keep the cash flow forecasts regular and up to date. Carry out that kind of basic options analysis. Have all of that there. Finally, particularly for the trustees, despite what we've said about probably you've got protection, have they got appropriate D&O cover, and do you need to notify under that cover? They haven't got that insurance, looking to getting so, but bearing in mind there are limited providers at the moment, and that cost can be steep for relatively limited cover. The other point on the D&O insurance is, particularly if you're looking to help a charity solvently close, is making sure you keep that run-off cover in place. I'd just like to say thank everyone for listening to this webinar. Hopefully we've given you a good steer on some of the key issues, some of the challenges when you're dealing with charities, and also some kind of context between how those duties and responsibilities fall when you're dealing in this sector. But it can be a very interesting, challenging and very rewarding sector to work for. And as I said at the start, you can be dealing with a multiplicity of businesses underneath a charity wrapper. So thank you everyone else for your time, and obviously our details are there if you have any queries. Thank you.